Of course, not all business activities that operate in Zambia operate legally, but for commercial businesses, or most commercial businesses operate, and those that want to must register with PACRA, that is, Patent and Company Registration Agency. Those businesses must include a business name, for example, a sole trader, partnership, etc. This is done under the Business Name Registration Act. And for incorporating bodies or companies, private, public, and foreign branches must be done under the Companies Act. Once a business entity has been registered under PACRA, it becomes a legal entity or name recognized under Zambian law. This gives a benefit of many forms of business activities. And the main reason why I'm talking about the Zambian law is because the general rule states that ignorance is not a valid excuse for committing a crime. It is mentioned under the Penal Code 87 of Section 7 of the Constitution. I am Jalison Pokota, speaking knowledge in law at Mulungushi University, and here I'm going to give a brief summary of what is found in law and business. So let's begin with what is law. Law is a body of rules and standards that differentiate between what is acceptable and from what is not acceptable in a community or country. These laws are formed by the parliament. The parliament is what creates these laws, and then they can later be added in the constitution. So the constitution it's like a book where the rules and regulations are put for the nation to follow, which is the supreme law on land. And that's the reason why for the government to pass down the Bill 7, which they wanted to pass down, it had to go through parliament because they can't make laws without laws coming through the parliament. And this is where even all the business rules and regulations are found. All of them are found in the constitution, which is formed by the parliament. Note that most of the Zambian laws are inherited from England. Therefore, we refer to similar cases that happened in England in order to pass on a similar verdict. And we will continue to add our very own as time goes on, I guess. So what are some of the law terminologies in terms of Zambian businesses? Let's start with claimant or plaintiff, a person applying for relief against another person in action. Suit, petition, or any other form of court proceeding. Defendant, a person against whom a court proceedings are brought. The reports of cases decided by the court comprising a statement of facts of every case and the reasons the court gave that judgment or for that judgment. Legal action, a proceeding in which a party pursues a legal right in a civil court. Litigation, the taking of a legal action by a litigant. A litigant is a person who is a party to a court action. Petition, some actions are commenced by a petition rather than a writ, and the person who commences the action is known as a petitioner. A petition is a written application for a legal remedy or relief that is only available if statutes or rules of procedure permit it. A respondent, the defending party to an application, appeal, or petition to the court. With a formal written order issued by a court that commands someone to do something or stop doing something. But now, since we're dealing with business, let's talk about contract law. So what is a contract? A contract is an agreement between two or more persons whose breach gives a rise to legal remedies. A contract may be expressed by oral or written format or contract. A valid contract includes 1. An offer, 2. An acceptance, 3. A consideration, 4. Intention to create legal relations, 5. Capacity, and finally 6. Legality. So an offer, what's an offer? An offer is an expression of willingness to contract on terms that are specific requiring only acceptance to form a binding agreement. The person making an offer is called an offeror, while the person accepting is called an offeree. For an offer to be considered as valid, it must have the following elements. Number 1, it must be clear, stroke certain. In Gothing versus Lin, an 1831 case, the claimant offered to purchase a horse at 69 euros and suggested that you add more if the horse was lucky. It was held that the offer was invalidated by the ambiguity of the word lucky. Did it mean fortune or was it the name of the horse? Number 2, an offer may be made to a person or a group or the public at large. In Kalili versus Carbolic Smokeball and Company Limited, in 1993, an 1893 case, the company, the defendant, made an inhalant for prevention of influenza and advertised its efficiency in a local newspaper. The company assured customers that whoever used the smoke ball and caught a fever could be compensated 100 euros and that 1,000 euros was already deposited in Alliance Bank, a Regent Street, to show how serious they were in the course of medication. But one of their clients still got sick and she requested for compensation but was rejected by the company and she sued to enforce her claim. It was held that she was entitled to the compensation. 3. An offer must be communicated by the offeror to the offeree or someone who has the authority of the offeror. Number 4. An offer can be withdrawn at any time before it is accepted. Now let's distinguish between an offer from an intention to trade. An intention to trade is a willingness to receive offers. For example, auction. The auctioneer invites people to bid on goods. An offer is a bid made by the customer and the contract is made between the auctioneer on behalf of the owner of the goods and the highest bidder. Acceptance of a bid is signified by the full knockdown of a hammer by the auctioneer. Display of goods on shelves of self-service shops is an invitation to trade to customers to pick up the goods from the shelves and make an offer to the shop. There was a case of Mr. Partridge versus Christine in 1968, where it was held that Mr. Partridge has not broken the law which protected bumblefinch birds by advertising bumblefinch cocks and hens at 25 each. This was not an offer but an invitation to trade. Notwithstanding that, the sale was completed when Mr. Thompson answered the advertisement, enclosing to check for 25 and the birds was sent to him. Display of goods on windows of shops is an invitation to trade. The invitation to trade to the customer to enter the shop and make an offer by showing the shop attendant what he has chosen. And if the attendant accepts the price, the contract is made. In Fisher versus Bell, a 1961 case, it was held that the display of a flick knife in the window of a shop did not contravene the restriction of the Offensive Weapons Act 1959, which was prohibited. Offering for sale offensive weapons including knives. This was an invitation to trade. Number 4. Letters from local authorities to sitting tenants requesting them to buy own houses. Invitation to trade. Goods and services advertised in the print and electronic media. Invitation of the public to subscribe for shares in a public company. Price indication. the display of price tags on goods, or a discussion about price, not an offer but an intention to trade. In Harvey versus Percy, a 1993 case, AC 55 to Harvey wanted to buy a farm belonging to Percy and sent him the following telegram: "Will you sell me a bumper whole pen?" The telegraph lowest price. Percy replied, "Lowest price for bumper whole pen is €100. Harvey replied, "We agreed to buy bumper whole pen for €100 as you asked, or as asked by you." The defendant did not reply, and the claimant sued for an order of specific performance, depending that the defendant should sell the farm to him. It was held that the reply by Percy was a mere statement of the price, an invitation to trade, and not an offer. Percy was not therefore bound by a discussion with Harvey and could sell the farm to anyone else. Definition of an offer: revocation before acceptance and be effectively communicated. Lapse of time, death, counter offer, acceptance. Acceptance. Acceptance is the final and unqualified expression of assent to the terms of the offer. Rules that govern acceptance. Number one, acceptance must be absolute, unqualified, and unconditional. Mere inquiries, number two, do not count as rejection. Not everything said by the offeree during negotiations of a contract is a counter offer. In Stevenson vs. McLean, an 1880 case, 5 QBD 346, the offeree, in response to an offer to sell iron, agreed on the price and quantity, but wanted to know whether the delivery could be staggered to give him time to arrange for storage. The defendant never responded, and the offeree sent a letter of acceptance. He sued on discovering that the iron had been sold. The offeree's defense was that the offeree had made a counteroffer. It was held that this was just a mere inquiry on details. Number three, postal rule. The rule states that the contract is made when a letter of acceptance is posted, even if the letter is delayed or lost as a contract. This rule was established in the case of Adams versus Linsdale, an 1818 case, 4 EXT 216. Number 4. Silence. Acceptance must be communicated. If the offeree is silent, this cannot be interpreted as an acceptance. Consideration. It is some rights, interest, profit, or benefit occurring to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. A simpler definition is found in Dunlop and Selfridge and Company Limited, a 1915 case, AC 8047, where consideration is defined as the price which buys the promise. Types of consideration. There are three types of consideration. Number one, executory consideration. Here parties exchange promises to perform an act in the future, e.g. Daliso promises to deliver fish and Wulaya promises to pay for it. Number two, executive or executive consideration. A party promises to do something in return, or an act of forbearance, e.g. giving information to obtain a reward. In this situation, performance of an act is required before any liability accrues. Number three, past consideration. This does not constitute the consideration at all. Rules that govern consideration. Number one, consideration must be real or valuable. Number two, consideration must not be illegal. Number 3, consideration must not be passed. Number 4, performance of a public duty. Number 5, consideration must move from promisee to promiser. Number 3, intentions to create legal relations, domestic relations. If a husband and the wife are not living together in peace, or are separated or about to be separated, there may be intention to create legal relations in the domestic arrangement, merit versus merit, and also the case of Pierce versus Miriam. Vitiating factors. A vitiating factor is anything that makes a contract void or voidable. For instance, misrepresentation, mistake, or legality. Misrepresentation Misrepresentation is a false statement of fact made by either before or at the time of making the contract, which induces the other party to enter a contract. This contract can either be a verbal or oral contract. When it comes to the element of inducement in misrepresentation, the following questions must be answered. Remember, a representee is a person to whom a statement of fact regarding the contract is made. The effect of misrepresentation, that's actionable misrepresentation, is that the contract is voidable. This gives the innocent party the right to claim for damages or rescind the contract. Elements of misrepresentation. A false statement of fact. The statement can either be expressed or implied by conduct. The statement should not be vague or mere puffs or opinions. Characteristics of a false statement of fact. Number 1, it must not be a statement of opinions. They must be made by a person who's an expert in that field. So you can see Belset versus Wilkinson, a 1927 case, AC 177. Facts. The seller of a piece of land indicated to the purchaser that the piece of land could support 2,000 sheep. This was not the case. The seller did not have the requisite experience in keeping sheep. However, the purchaser bought the land and sold for misrepresentation in an attempt to rescind the contract because the purchaser discovered that the land could not sustain that number of sheep. It was held that the statement made by the seller was an opinion because the defendant did not have the personal experience in sheep farming. As earlier stated, vague statements and mere puffs do not amount to misrepresentation. Mere puffs are those statements, mostly made during advertisements, which are usually exaggerated. You can see Dimwok versus Hallett, 1866 case. Facts. The seller of the land claimed that the land was fertile and improvable. Later, after Mr. Hallett won a bid at the auction for the piece of land, it was discovered that the land was not very fertile and improvable. In an attempt to rescind the contract, he sued for misrepresentation. It was held that there was no misrepresentation as the statement was not a statement of fact, rather it was a mere flourishing description and did not entitle the buyer to rescind the contract. Half-truth are also another example of misrepresentation. This is where the representer misleadingly tells only part of the truth. In the Dimlo case above, aside describing the land as fertile and improvable, said that it was let out to paying tenants. However, it was not mentioned that by the time of the auction, the tenants were already given notice to quit the property. This court noted was a misrepresentation. Number 3, statements as to the future. What we must note here is that generally statements as to what someone will do in the future do not amount to an actionable misrepresentation unless it's binding as a contract. You can see Petroleum versus Madon in 1976 case, QB801, and indeed G-Tone versus Fizz Maurice, an 1885 case, 29 chapter D459. In the indeed John case, the claimant bought shares in the defendant's company on the premise that the shares were being sold because the company was expanding. The company was not actually doing very well and they needed the money to pay off some of its liabilities. In this particular instance, the claimant could claim misrepresentation because the defendant's intention was not what he said it was. Silence is another example of misrepresentation. Generally, silence does not amount to misrepresentation. You can see Smith and versus Hughes, an 1871 case, 6 QB 579 Oates case. However, misrepresentation could be implied in certain instances. When the statement made in the course of negotiations subsequently becomes false. You can see with versus of Flanagan in 1936 case, CH 575. Facts: Mr. of Flanagan wished to sell his medical practice and gave information to the plaintiff about the income he derives from the practice, which was true at that time. However, Mr. Olive Flanagan fell ill and this income drastically reduced or reduced. The defendant, during the entire process of concluding the sale, which took about 6 months, did not disclose the information about reduced income. On discovering the state of the practice, the parties sought to rescind the contract. When the silence, they sought a true statement. We can see Ara versus Kentland in 1931 case, 1KB442. Facts of the case: a company that was falsifying its accounts invited members of the public to purchase its shares. That's it. Had paid its shareholders dividends during the entire period of depression. The indication of that company operated at the profit during this time. Held inter alia that the company's silence as the source of its dividends was a misrepresentation because it distorted the true statement that dividends were paid out. Contracts of Rebelling Fidei, utmost good faith. These are contracts that create a relationship and trust and confidence. You can see Tate versus Williamson in 1866 case 2CH up 55. Defendant's conduct. This one we can see Gordon versus Rico Limited in 1986 case 278 EG 53. Statements of law. A false statement of law is not an actionable misrepresentation because everyone is presumed to know the law. A7 of the Penal Code, Cap 87 of the law of Zambia provides that ignorance of law is not a defense. You can also see Solo versus Butcher in 1950 case 1KB671. That's a misrepresentation. These are three types, so there are three types of misrepresentation. These are fraudulent misrepresentation, fraudulent misrepresentation. A fraudulent misrepresentation is one made either A, knowingly, B, without belief in the truth, C, recklessly and carelessly. Taking foregoing into consideration, the test for fraudulent misrepresentation is or has there been an absence of honesty in a statement, and did the representer aim at deceiving the representative? In this one, we can see the case of Derry versus Pick, an 1889 case, OR14. Number 2, neglect misrepresentation. This is the type of misrepresentation where The representative has belief in his statement, but fails to exercise reasonable care and skill ensuring that the statement is true. When it comes to this type of misrepresentation, the success of it depends on whether there is proof of the special relation between the parties. That is, where one party has special knowledge of the matter. In this instance, the party that suffers a loss due to the misrepresentation can claim economic loss. With this one, we can read the case of Hadley Barney versus Scheller and partners, the 1964 case, AC 464, and also the Aesop Petroman versus Maddon. The third one will be innocent misrepresentation. This is a statement without any probable fault. That is, a statement that is made while the presenter genuinely believes it to be the truth. This one you can read the case of Lip versus International Galleries, the 1950 case, 2KB86. Remedies under misrepresentation. There is number 1, discussion, number 2, damages, number 3, indemnity. Mistake. Mistake is a factor that affects contracts that would otherwise be effective. It happens when one or both parties to a contract wrongly believe that certain facts are true at the time they enter the contract. Mistake can be divided into 3 categories. This one was determined in the Sepen versus Tepen 59 BC LR 26 case. These 3 categories are common mistake and neutral mistake. Neutral mistake is the third one. Common mistake. Common mistake occurs where both parties make the same mistake. This happens where the parties are mistaken as to some fundamental fact regarding the contract, thus making the performance impossible. Common mistake can occur in the following instances. Mistake as the existence of the subject matter. This is where the parties enter a contract to buy and sell goods which are unknown to either party, do not exist. You can read Griffith versus Bremer, a 1903 case. The effect of a mistake as to the existence of the subject matter is to render the contract void. Add into B. Mistake as to title resource. This is where A and B enter a contract to buy and sell goods which are known to either party already belongs to A. In short, this occurs where a party agrees to buy property that he is unaware belongs to A. You can read Copper versus Philip, an 1868 case, and Bell versus Lever Brothers, a 1932 case. The effect is to render such contract generally void and unenforceable. Mistake as to quality. This mistake relates to the fundamental quality by which a product is identified. It was noted in Bell versus Lever Brothers that mistake as to quality will not affect assent unless it is a mistake of both parties and it has the existence of some quality which makes the thing without the quality substantially different from the thing it was believed to be. So mistake. This is where one party is mistaken as to the nature of the contract and the other party is aware of the mistake, or the circumstances are such that the other party may be taken to be aware of the mistake. A neutral mistake may occur in the following circumstances. A mistake as to the identity of the other party. This is where a party enters into a contract with someone believing him to be someone else. You can read the case of Cindy, which is Lansing, a 1878 case, or Lewis versus Avery, a 1972 case, or Philip versus Brooks, a 1918 case, or 1960 case of Ingram versus Lead. Under mistake, as to identity, two particular incidents must be taken into consideration. That's it. One, a contract made interpretees. This is why a contract is made with, but not in the presence of each other. Such a contract is a void contract. Two, contract made interpretees. This is a contract made where both parties are face to face. Here, the presumption is that the mistake party intends on dealing with the person they are seeing. This can be rebutted if 1. The mistaken party shows that they are intended to deal with someone else. So the party they dealt with knew of the information, that is, the other party intended to deal with someone else. 3. They regarded identity as towards of crucial importance. 4. They look reasonable steps to check the identity of the other person. Mutual mistake. This is where both parties had cross purposes. This means the parties misunderstood each other's intentions. Here the court applies a reasonable test. That is, would the reasonable man take the agreement to mean what one party understood it to mean, or what the other party understood it to mean? You can read Wood versus Card in 1858 says, where there is a mutual mistake, there is incense in no contract because there is no acceptance. Acceptance must tarry with the offer, and in a mutual mistake, the parties already at cross purposes. Mistake written to documents. None is punctum. This is what I did. Generally, a person is bound by their signature to a document, whether they know it or not, or whether they've read it or not, or they have understood the document or not. However, where a person has been induced by fraud or mispresentation to sign a contract, they can plead non is punctum, meaning is not my deed. To further understand this, you can read in the case of Foster versus Makikon, an 1869 case. Duress and undue influence. The formation of a contract requires offer and acceptance. Among other things, these two principles indicate that there should exist between the two parties or the parties involved a freedom to contract. That is, the contract must be entered into voluntarily and freely. There are two basic instances which rebut this presumption. These are duress and undue influence. Duress. Duress occurs when a person is compelled or coerced to enter into a contract by the use of force, either physically or economically. Duress occurs in many forms. These include duress to person. This involves the use of actual threat or violence on a person. B. Duress to property. Generally, a threat to property does not amount to duress. However, such a threat can amount to duress in one instance, that is, where the property does not belong to the person being forced or threatened. That is, property in your custody but does not belong to you. See, economic duress. This duress is questionable where there is illegitimate commercial pressure. In whatever form duress occurs, it's important to note that under common law, duress is voidable. Further, in whatever duress occurs, this question is whether there has been illegitimate pressure. A threat becomes illegitimate either A, because what is threatened is illegal, B, the threat itself is wrongful, contrary to the public policy, or it amounts to unconscionable or unconscionable conduct. It is important to understand that duress does not leave the other party without a choice, but it puts that party in a position where no other practical solution is available. Baton versus Armstrong, 1973 case. Can explain further on this. The undue influence stems from the relationship based on trust. It comes from a situation where the stronger party in the relationship takes advantage of his dominant or her dominant position to induce the weaker party to enter a contract that is not beneficial to that party. The difference between duress and undue influence is that when it comes to undue influence, no actual threat or violence is involved, as in the case with duress. Undue influence occurs in two forms, that is, one, actual undue influence, where the claimant must prove that the wrongdoer exerted undue influence onto the complainant. So, presumed undue influence, where the claimant has to show that the fiduciary duty exists and the other party abused their relationship in procuring the complainant to enter into the impact transaction. Effects of undue influence. The party who claims undue influence is entitled to avoid the contract. Unconscionable bargain. An unconscionable bargain is a contract bargain whose terms are so unfair that they lack conscience. Entity therefore may give relief when an unfair advantage is taken off a person who is arrogant or weak-minded or is some reason in need of special protection. Illegality. On the face, contracts are illegal if they don't meet the needs or the requirements of a valid contract. However, public policy or the law may bar the enforceability of that contract on the basis of illegality. When a contract is illegal, there are no remedies of enforcement or recovery of property transferred. However, there is an exception to this rule, in which the court may permit the recovery of property or money. This exception includes 1. Are the parties in the prior delito, where the party or parties have been pressured to enter into contract by undue influence. Duress or mispresentation. Property can also be recovered. For further understanding, can read the case of University of Liverpool, Victoria, Legal Friendly Society, 1916 case, or British Workmen's and General Assurance Co. versus Canning, a 1902 case. 2. Did one of the parties repent before the performance of the illegal contract? If the illegal transaction has not yet been performed whole or in part, then voluntary withdrawal will normally lead to the recovery of money or property transferred. B. At performance, this refers to the legality in which the contract is performed. In this instance, the innocent party might possess the normal contractual remedies. So understanding can read the case of Muhammad versus Itowala versus Variety Bureau, the change. It was the one case. Further, a contract may be illegal under statutes or common law. Legal contracts under common law on grounds of public policy. A contract is said to be contrary to public policy when they have a clear tendency to bring about a state of affairs which the law regards as harmful. This can occur in the following instances. Number 1. Contracts to commit fraud. A tort or a crime. You can read more about this in the case of LMS's Viscas, a 1676 case. 2. A contract involving sexual immorality. So you can read more about this case on Pierce versus Brooks, an 1866 case to explain more about this. 3. Contract to promote corruption in public offices. You can read about this more on Garforth versus Pearson, 1786 or 87 case. 4. Contracts designed to defraud the revenue. You can read more about this in the Miller versus Castlink, a 1945 case. Restraint of trade. Restraint of trade refers to contracts that restrain someone from conducting business. Such contracts are not necessarily illegal but void unless there are instances of protecting trade secrets. To understand more about this, include the case of Aesop Petroleum versus Harper's Garage, a 1968 case. Discharge of the contract. Discharge of the contract relates to how a contract comes to an end. The following are the ways in which a contract may come to an end. A. By performance. This happens when both parties perform their obligations in order for a contract to come to an end by performance. The performance of the obligation must be correspond with what the parties have agreed. By agreement, the parties mutually agree to end the contract, to form a new contract, thereby ending the earlier contract or vary the old one. A shop detective item is retained either for a new one or a refund. By breach, where one party forced to perform the end of the contract, the other party has a right to end the contract. This releases the parties from future obligations. However, it is important to note that it is not all breaches that call for termination of contract, in that there may be conditions in that contract and warranties. A condition is a fundamental term in a contract whose breach gives the aggregated party the right to terminate one contract or terminate the contract. A warranty is a minor term in the contract that gives the right to the aggregated party to claim for damages. Let's learn more about this into the case of politic shipping versus De Leon. Anticipatory breach or breach. This is where one party indicates that they are willing to perform their side of the contract. Thus, the other party is aware of the breach before it occurs. By frustration. Frustration is an unforeseen event by both parties that renders performance of the contract impossible, illegal, or different than what was originally agreed. In order to prove frustration, there are three ingredients that must always be present. Number one, the event must be unforeseeable, e.g., COVID. Number two, that is, no fault of either party. Number three, performance becomes impossible, illegal, or differs from what was originally agreed. For the earlier mentioned ingredients, read the case of Taylor versus Cowell, an 1863 case. Davis Constructors Limited versus Farham Urban District Councils, a 1956 case, and the case of Carroll versus Henry, a 1903 case. Categories of frustration. While the subject matter is stray, does cease to exist. You can read more about this on Taylor versus Caldwell. The frustration of purpose. Carroll versus Henry. C. Incapacity of death. You can read more about this using the case of Robinson versus Davison, an 1871 case. Frustration by choice of law. Frustration by delay. Legal effect of frustration. Generally, the parties are discharged from performance of any future obligations. Thus, money payable ceases to be paid and money paid is recoverable. However, this is only where there is a total failure of consideration. You can read more about this using the case or the Fiobosa case, a 1942 case. These damages. The purpose of awarding damages is to compensate the victim for the loss caused by the defendant's breach of contract rather than to punish the wrongdoer. In claiming for damages, it is important to show the following. Number one, the damages are not remote. There is a need to show a causal link between the breach and the claim. Let's learn more about this into the Surrey Courtney Council versus Peridot Holmes case, and also read the case of Rodley Electronics and Construction Limited versus Forthy, a 1996 case. Number three, the losses could not have been reasonably mitigated. Number two. And number three, the recoverable losses have been properly quantified. Specific performance. This compels the other party to contract to fulfill the terms of the contract, to understand more about this, include the case of Piswick versus Piswick, a 1968 case. C. Injunction. This seeks to refrain a defendant from committing a breach. D. Damages. Inequity. Damages guaranteed in law of or in addition to specific performance. To understand more about this, include the Worth versus Taylor, 1974 case. Tort law. A tort is often defined as a civil wrong, other than a breach of a contract or a breach of trust. The main purpose of the law of tort is to compensate the victims of wrongdoing for the injuries they suffer. The remedies for the law of tort is common law. Is a common law for unliquidated damages. Examples of a tort are negligence, a nuance, trespass, defamation, malice, falsehood, occupiers liability, and vicarious. Categories of a wrong under tort. A. 1. The mean saying injure. This means damage without injury. Damage without injury. This is or applies in instances where the interest is or is in contestation, is not protected or actionable by the law. To understand more about this, include the case of Mushemili Limited versus Intusumilinga Enterprise Limited. The second one will be injure same domain. This means injury without damage. The first meaning is that some interests are so important that their infringement is actionable per se, without proof of damage. An example of this is slander. The second meaning is that a right which is breached is actionable if proximate damage can be proved, otherwise it is an injury without any harm or damage incurred. Elements of a tort. There must be legal duty owed by the defendant to the plaintiff. There must be a breach of duty. There must be damage as a proximate result. Difference between a tort and a contract. Firstly, the duties in a tort are primarily fixed by law, while the duties in a contract are fixed by the parties themselves. Secondly, a claim for damages in tort is a claim of unequated damages, unspecified amount, whereas a claim for damages in contract is a claim that can be made for liquidated and unliquidated damages. Thirdly, a tort is specific duty owed to a wide range of people, while the duty owed to a contract is only owed to those that are party to that contract. The position of intention, malice, and motive in tort. Generally, motive or intention is not relevant to prove a tort, hence it's also not relevant to prove that the wrongdoer had malicious intentions. Malice has two meanings as follows: the intentional doing of some wrongful act without proper excuse, and two, the act with some collateral improper motive. In the case of Wilkinson vs. Downtown, a 1997 case, the defendant, by the way of a practical joke, falsely told the plaintiff, a married woman, that her husband had met with an accident whereby both his legs were broken. She believed this and was voluntarily upset, which led to her having a nervous breakdown or shock that she had a serious illness. After the defendant was held liable. Despite motive not being relevant to prove a tort, there are some exceptions where it is necessary. For example, 1. In a tort of minors persecution, the plaintiff must prove minors. 2. In a tort of defamation, if the plaintiff can prove minors, this will prevent the defenses of qualified privilege and fair comment. 3. In a case of nuance, the plaintiff will sometimes succeed if he or she knows that the defendant's minors than done otherwise reasonable act into an unreasonable one. To understand more about this, you need to read the case of Hollywood Silver Fox Farm versus Eminent 1936 case. Who can sue and be sued? In tort, generally all persons have the capacity to sue and be sued in tort except the following circumstances. The Crown. Number 1. The State Proceedings Act Cap 71 of the laws of Zambia provides that the state shall be subject to all liabilities in tort to which, if it were a person of full capacity and age, it would be liable. Number 2. Judicial immunity. A judge has the judicial immunity for acts in his judicial capacity. Counsel and witnesses have immunity in respect of all the matters relating to the cases in which they are concerned. Number 3. Foreign sovereigns and diplomats. The heads of states and diplomats are not actionable in torts. Number 4. Company. A company can sue and be sued in its own name. Number 5. Unincorporated bodies. In partnerships, the partners may be jointly and severally liable for torts committed by partners in the course of the partnership business. Number 6. Husband and wife. A husband is not affected by any action in tort against the wife. The wife is also not affected by any action in tort against the husband. Actually, a spouse may not sue the other spouse in tort. Number 7. Minors. A minor can sue in tort, but through an ex-friend. Number 8. Persons of sound mind or unsound mind. A person of unsound mind may generally be liable in tort except where the tort is questioned. The tort in question requires the element of a capacity to form intent or malice. Examples of torts. Number 1. Trespass to person. Trespass may be to a person, land, or goods. With regard to trespass to persons, it can take the form of battery, assault, or forced imprisonment. Assault refers to the causing another person to apprehend the immediate infliction of unlawful force upon his person, e.g. throwing a bottle, even if at first instance you miss. This one, to understand more, you can read the Tilbavel versus Savage, a 1669 case. Battery. Battery refers to the intentionally inflicting unlawful force upon another person. To understand more about this, you can read the Inco versus Stumai 13. Odds, CJ. We stated that the least touching of another in anger is battery. Secondary, if two or more meet in a narrow passage and without any violence or design of harm, the one touches the other gently, it will not be battery. Thirdly, if any of them use violence against the other to force his way in a rude, inordinate manner, it will be battery or a battery. Or any struggle against the passage to that degree may do hurt will be battery. Forced imprisonment. Forced imprisonment is an unlawful deprivation of another's liberty by imposing restraint on their freedom of movement of an individual. Article 13 of the Constitution states that no person shall be deprived of his personal liberty. Further, Article 22 states that no person shall be deprived of his freedom of movement. The elements of forced imprisonment include: number 1, restraint must be complete. For example, there must be on every side of him a boundary drawn beyond which he cannot cross. Number 2, restraint must be unlawful. Number 3, no means of escape. If a person has the means of escape but does not know it, his intention is nevertheless force, unless they or any reasonable man would have realized that he had an available outlet. Trespass. Trespass to land is a direct interference with the possession of another person's land without lawful authority. Trespass can manifest in the following ways: entering upon land. This includes remaining upon such a land after the invitation has been revoked, or placing upon such a land an object without license, permission, or lawful jurisdiction. B. Trespass to the air space. According to Section 12 of Aviation Act, no action shall lie in the respect of trespass or in the respect of nuisance by reason only of the flight of an aircraft over any property at the height above the ground, which having regard to wind, weather, and all the circumstances of the case is reasonable, or the ordinary incidents of such a flight, so long as the provisions of this act and of the convention are duly complied with. Negligence. Negligence is a breach of legal duty to take care, which results in damage to the plaintiff that is undesired by the defendant. The legal or the duty of care is responsibility that the person must exercise in order not to cause harm to others. There's a case of Mulungushi versus Silverstone 92 case that explains on this, where Lord Atkins said that you must then take reasonable care to avoid acts of omissions which you can reasonably foresee would be likely to injure your neighbor. He later defined what a neighbor is. A neighbor, according to him, are persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I'm directly my mind to the acts of or omissions which are called in question. The test of responsibility lies in what a normal thinking man would do. For example, the reasonable man foresees in the Paris versus Stephenly Butch Council, a workman only one good eye was lost of the eye from a splinter of metal. No goggles had been supplied to this workman. It was held that the employer should have been exercised greater care in his case than in that of a two-eyed. The duty of care also flows to instances of nervous shock. In the context of this cause of action, nervous involves the sudden appreciation by sight or sound of or a refined event which violently agitates the mind. How to prove negligence in tort. Res ipsa inquieta, the thing speaks for itself. Essentially connects the use of evidence in determining negligence. The doctrine of res ipsa inquieta will apply when the thing that caused the harm was under the control or management of the defendant. The accident should be such that the ordinary course of things does not happen if those who have management use proper care. For example, in the GV versus Metropolitan Railway in 1873 case, the plaintiff leaned against the door of a train shortly after it left the station. The door opened and the plaintiff fell out. It was held that the door had recently been under the control of the defendant. There was negligence from the defendant. Nuance. Nuance can be private or public. Private nuance is the direct, unlawful, and interference with another's use or enjoyment of land, or some right over or in connection with it. Nuance may come in three forms, that is, nuance by encroachment on a neighbor's land. 1. 2. Nuance may also be perpetrated by the direct physical injury to a neighbor's land. 2. 3. Interference with the neighbor's quiet enjoyment of his land. In the case of National Hotel Development Corporation TF Fairview Hotel versus Mutala 202 case, in this case is where the applicant used to play loud music at night on the terrace of his hotel, much to the annoyance of the respondent who lived nearby. Without this music, the applicant argued he would have less customers, which in turn would main financial loss for him. The appeal succeeded to the extension that there would be a conditions imposed and the order of an injunction reversed so as to permit the playing of music on the terrace up to 21:30 hours during weekdays and 22:30 hours during weekends. Occupier's liability. Occupier's liability is an occupier denotes is when an occupier denotes a person who has a significant degree of control over premises to put him under a duty of care towards those who are or who come lawfully on the premises. His duty is exceeded when, by taking reasonable steps to warn of the danger or to discourage persons from incurring the risk. To whom is this duty owed? Visitors, children, trespassers. Number 6. Returning. Detenue. Detenue consists of wrongful intentions of the possession of a chattel. Defamation. Defamation is the duty. This is the publication of a statement which reflects on a person's reputation and tends to lower him in the estimation of right-thinking members of society generally, or tends to make them shun or avoid them. Defamation can be in a form of libel or slander. Libel is a form of defamation expressed by print, writing, pictures, or signs. Defamatory words read out aloud by speaker from a written article and broadcasted by radio constitute libel. Slander, the speaking of false and malicious words concerning another, whereby injury results to his reputation. Defenses against defamation, truth, fair comment on the matter of public interest, privilege. This can be absolute or qualified privilege. Vicarious liability. Number 8. Vicarious liability is the legal responsibility imposed on one party, for example, an employer, for the actions of another. For example, an employee undertaken within the scope of employment. Number 9. Strict liability. The rule in Reinder's versus Fletcher in a 1868 case. In Reinder's versus Fletcher, the defendant had employed independent constructors to construct water a reservoir on their land. These constructors found disused mines when digging but failed to seal them properly. They filled the reservoir with water which is in turn flooded through the mine shafts into the plaintiff's mines on the adjoining property. The House of Lords held that the defendants were liable. The House of Lords stated that the person who, for his own purposes, bring on his land and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and if he does not do so, he is prima facie answerable for all damages which in the natural consequence of its escape. He can excuse himself by showing that the escape was owing in the plaintiff's default, or perhaps that the escape was the consequence of this measure or the act of God. Defenses to trespass. Number 1. Lawful arrest. 2. Consent. 3. Contributory negligence. 4. Prevention of trespass or ejection of a trespasser. 5. Parents or other authorities or other authority. 6. Indemnity accident. 7. Voluntary non-fit injury. That means which a person assents is not regarded as in law as an injury. Agency. Agency, this is the relationship between two persons by agreement, where one, the agent, may act on behalf of the other. the principle and bind the principle by words and actions. That's from the Black's Law Dictionary, 6th edition. Agency can only subsist where the principal and the agent agree to the relationship and the principal authorizes the agent to act on his behalf. This authorization takes many forms, and these include: number one, apparent authority. A person may be bound by acts of another on his behalf and without his consent, or even breach of an express prohibition of his words or conduct to create an impression that he has authority. He has authorized the other person's acts enough for apparent authority to exist. The following must be considered: A. A representation by the principal. There must be a representation made by the principal to the third party, intended to be, and in fact acted on by the third party, that the agent has authority. B. Reliance. The third party must in fact act on the principal's representations that the agent has authority. C. Contract must be within the capacity to the principal. This means that the principal must in fact have the capacity and the power to enter such contracts. Actual authority is a type of authority that is explicitly given to the agent. Implied authority. This arises in a situation where, although a particular action is not sanctioned by any express agreement between a principal and an agent, the principal is nevertheless taken to have implicitly consented to the action of or transaction in question. An agent who has express authority to carry out a particular task may also have additional authority to do certain acts which are incidental to his authorized task. For example, an agent who is explicitly authorized to sell the principal's property has implied incidental authority to sign a contract of sale. Types of agencies. 1. Agency of necessity. A person who acts as an agency, for example, to preserve the property or interest of another, may be treated as an agent of necessity, with the result that his actions will be deemed to have been authorized even if no actual authority had been given. For this type of agency, there must be a genuine commercial emergency, and as a result, the emergency, it must have been practically impossible for an agent to obtain instructions from the principal. Agency arising from cohabitation. It has sometimes been argued that the wife has authority to pledge her husband's credits for necessity. The presumption can be rebutted by the husband when he can show that his wife is adequately supplied with necessities of life. 2. They are provided. He has provided the wife or his wife the adequate allowance. 3. He has forbidden his wife to pledge his credit. Agents of ratification. Hence, a ratification, if an agent does something that is not authorized, it may be held that the act was nevertheless done negligence if the principal later ratifies it. Agency by implication. An agency may arise although there is no specific agreement. A contract can be implied from the conduct or relationship of the parties. Types of agencies or agents, type of agents. Secondarily, agent is one who guarantees to his principal that the third party will perform his contractual obligation to the principal. Commercial agents. These are self-employed intermediaries who have continuing authority to negotiate the sale or purchase of goods on behalf of another person, the principal. The broker, an agent employed to make bargains and contracts in the matters of sales or trade, commerce, or navigating between other parties. General agent, an agent with authority to represent the principal in all businesses of a particular kind. Duties of an agent. 1. Duty to obey instructions. An agent has a duty to obey lawful instructions of the principal. Of course, the instructions should be in relationship to the subject matter of the agency. So, duty to exercise due skill and care. The agent has a duty to exercise due skill and care. Failure to do this would be liable for breach of the duty. 3. Duty to make full disclosure. The agent's interests conflict with those of the principal. The agent is barred from acting, but without full disclosure to the principal of his own personal interest in the man or matter. 4. Duty to avoid conflict of interest with principal. This situation is likely to arise while the agent proposes either to buy the principal's property himself or to sell his own property to the principal. 4. Duty to not make secret profits and avoid bribes. An agent is not allowed to make any additional profits as a result of the agency unless he discloses them. These are called secret profits. Duty to account. Number 5. Agents are required to keep property or money belonging to the principal separate from their own. Definition of an agency. An agency relationship can be demonstrated in the following ways. Number 1, by agreement. This is where both the principal and the agent agree to terminate the agency relationship. Number 2, the death of either party also terminates the agency. Number 3, agency relationship may also be terminated by the operation of the law. For example, if the performance of the agency becomes illegal or impossible. Number 4, insanity of either party also terminates the agency relationship. Number 5, the principal may terminate the agency authority if he commits or she commits a serious breach of duty, such as making secret profits. Sales of goods. What constitutes a sale of goods? It's a contract of a sale of goods by which a seller transfers or agrees to transfer the property and goods to the buyer for a money consideration called the price. The difference between a sale and an agreement to sell. 1. Where the transfer of property ownership takes place immediately from the seller to the buyer, the contract is called a sale. Where the transfer of properties is to take place at a future time or subject to some condition to be fulfilled, the contract is called an agreement to sell. Characteristics of a contract of sale. The transaction must be for a price in mind. The contract should involve the transfer of property and goods. Once the property has passed from a seller to buyer, the seller can sue for the price, even if there has not been a delivery. If the seller resells the goods after the property in them has passed to the buyer, the second buyer acquires no title to the goods unless he is protected by one of the exceptions to the Nemo debt rule. Nemo the true number height. No one gives who possesses not. Classes of goods. Number 1, they can be existing or future goods. Number 2, specific, asserted, and unsettled goods. And finally, what would be the remedies for a buyer? Remedies of a buyer include number 1, damages, including a damage for non-delivery and damage for delay in delivery. Number 2, repayment or diminution of the price. Number 3, other remedies such as specific performance. What are the remedies for a seller? Number 1, a lien on the goods for the right to retain them for the price while he was in possession of them. A lien is a specific right of a person such as a bali in possession of goods to retain those goods until any claim he has on or in respect of them has been satisfied. Number 2, in case of the insolvency of the buyer, a right of stopping the goods in transit after he has parted with the possession of them. Number 3, a right of resale as limited by the Act. In this case, where the goods are perishable in nature, or where the unpaid seller gives notice to the buyer of his intention to resell. With that, I finished my lecture on business law. This is a bibliography and some references I use for the notes I compiled. If you're interested in uh, notes or similar content about this, just simply text or inbox under the comment section below. And if you're looking forward to contact me, you can simply find me on X as Taliso Mpokota. You can also find me on Facebook and Instagram by the same details. Just click the follow button on Instagram, Facebook, and X. And with that, I conclude my video. Thanks for watching, and see you next time.